So I'm Christine, and I'll be moderating the session. And I am part of the Africa Asia team. And I will have Rosemary introduce herself, then Juliana, then Amanda, and then we will get started with the discussion. So Akin, you go first, introduce yourself, then Rosemary introduces herself, then Juliana, then Amanda, and then we'll get started.
Hi guys, I'm Rosemary Koech Kimwatu, a public policy lawyer based out of Nairobi. I work for a communications and public policy firm known as Oxygen MCL. However, I'm affiliated to a good number of organizations that are active in the tech space. I'm a co-founder of the Legal Hackers Nairobi chapter. I'm also affiliated to the Kenya ICT Action Network, where we come together to discuss poly issues. And I'm also a member of Kenya Digital Innovation Group, where we just sit together, players in different sectors, regtech, regulatory affairs, technology, and actually all these groupings discussing the intersection between the law and technology. And I think today's topic is really cuts right at the center of this relative practice. So yeah, it's a pleasure to be here. Looking forward to a great engagement.
Cool. Thanks, Rosemary. Juliana?
Hello, everybody. I'd first like to thank Christine for the kind invitation to participate in this panel today. It's a pleasure to be here and to learn more about internet regulation and legal tech in your countries as well. My name is Juliana Navarez. I am an LLB candidate at the University of São Paulo. I'm currently in the last months of my law degree. I'm also part of the Directive Council of the Youth Observatory, which is a special interest group of the Internet Society that aims to engage young people into Internet governance and technology policy. And I am an International Rights Fellow at Article 19, a global organization that works with freedom of expression and information. And I'm currently developing a project related to connectivity in Latin America and telecommunications regulation. Thank you very much.
Thank you, Juliana. Amanda.
Hello, everyone. I am Amanda Manyame, and I'm based out of Johannesburg, South Africa. I am a digital law advisor, and I work right at the intersection of law and technology. I am a very strong proponent for public interest technology, and I do a lot of research in technology and laws and the different laws that here inform how tech is used in Africa, as well as how it intersects with the different human rights that we have. I'm also a core lead on the capacity building team for the Innovation Law Club in Africa, which is essentially a club that was formed to try and make sure that each and every tech law practitioner on the continent has a space where they can find information about technology law, as well as engage and network with each other. It's very nice to be here, and thank you so much, Christine, for the opportunity.
Thanks, Amanda. Akin, hopefully we can hear you now. Let's try. What we could do is let's start on the discussion. Then hopefully we will be able to hear you much better. So if I may quickly introduce, for the sake of Akin, on what we are trying to do is that we are trying to have people who are practicing in different African countries, in different areas, speaking to each other and getting to know each other and networking and getting to hear who is doing what where in their common areas of practice. And that's what we normally try to do. And we've had different discussions, but this is the first of its kind in that first having Juliana, who is from out of Africa, to share her experience in the area. But then also the other thing is the first in the legal and tech space kind of discussion. Any discussion we've had has either been purely on tech, with maybe software engineers or innovators who are trying to have different kinds of apps or such kinds of things developed within Africa. So it's really nice to have you guys. So if I could start with Amanda, if you could speak on the regulations, the laws that exist within your jurisdiction of practice on cybersecurity and in the digital space, and Are they industry specific? Like, are you looking at advanced laws like within the finance sector, the telecommunication sector, or what does it look like from your jurisdiction where you practice?
Well, in South Africa, there are quite a few laws that govern the digital space. So one of the first laws that was enacted a few years ago is the Electronic Communications and Transactions Act, and that is the act that someone who's working within this digital space is most likely going to go back to, because that is the one act that kind of dealt with digital law, digital transactions, e-commerce. It dealt with essentially everything in the digital space, and this was in 2002. So now, as we have transitioned in the country, and we're getting more and more laws that are, for example, the data protection law, which is a 2013 law but only came into effect in 2020 this year, as well as a Promotion of Access to Information Act. We now have these new acts, but because these new acts are industry specific or deal with a specific theme within digital law, you always end up going back to the Electronic Communications and Transactions Act. But essentially, we do have quite a few acts, and at the end of the day, if you go back to the Electronic Communications and Transactions Act, you will be able to either deal with e-commerce, you will be able to deal with cybersecurity. There's a cyber crimes bill that might be signed into law very soon. It has passed all the loophole. It has passed all the steps that it needs to pass, and it's now sitting with the president and will be signed into law. We would say any day now, but it could take a year or so. It really depends. But yeah, those are essentially the laws that deal with cybersecurity and govern the digital space.
How advanced is the South African like legal space if you compare it maybe to other jurisdictions as you possibly had people speak or practitioners in the areas? What's South Africa cybersecurity regulation space like? Is it advanced at the beginning or just at the basic?
Um, well, the African countries that I have looked at, I would believe we are similar in many ways, in that technology has evolved so quickly, and our laws have been found wanting, in that you will find that the tech space has morphed to an extent into one industry. So if you look at health tech, if you look at the fintech space, you are dealing with different industries that have been put together, but our laws govern them separately. So yes, South Africa does have a few good acts, but these acts are dealing with the themes or the industries separately, which would be a concern, considering that tech has now moved a number of these sectors into one. Well, you want to call it one big sector, but yeah. So it's maybe we would say in the middle, if
Okay.
you like.
And Rosemary, what is it like in Kenya? What are the like cyber security laws, regulations like? Yeah.
Mhm. So thanks for this. So we have a number of regulations that are there. We have the traditional ones that have been there for a while. We have the Kenya Information and Communications Act that basically gives regulations. The primary law regarding the telecommunications in Kenya that set up the Communications Authority, and it started, of course, with the primary services that we're all used to: telecommunication, radio, broadcasting, and postal services. But now we've seen an evolution, and actually it also mentions about electronic transactions and cybersecurity. So these are through amendments of the regulation that have happened over time. So it talks about electronic reports, retention of information, and all that. But with time, there also a need to advance to more tech-related laws. So we have the Kenya Computer Misuse and Cybercrimes Act that was passed, I think, in 2018. But there was a contest in court in our Kenyan Supreme Court, where the issue was, are some of the sections of that particular act constitutional? So one decision held, actually early in the decision, in the court case, it was some of the sections are suspended, but later those sections were reinstalled. So the Computer Abuse and Cybercrimes Act stands as it is. And then we also have the data protection law in Kenya. We've had drafts for a number of years, but finally last year, I think we settled on one. Of course, pressures of international practice like GDPR led to the fast tracking of that. So in 2019 November, the Data Protection Act was promulgated, but also in terms of subsidiary regulation, we have cybersecurity guidelines offered under various legislations. Like for the banking industry, we have the Central Bank of Kenya cybersecurity guidance notes. So yeah, that's basically the Kenyan landscape, and that's a small outline of what it is.
So,
Though there's a lot of development of law that's happening, there's a lot of jurisprudence that is being pushed. We're seeing different ways we didn't expect these laws to be utilized. And right now, the biggest issue I think in Kenyan computer laws is the conflict between traditional rules, traditional issues like freedom of expression, freedom of information, and can some of the laws be misused to in one way or another. So I think those are issues that come in the minds of say regular internet users in Kenya.
And how do you compare Kenya to South Africa? Is it like on the same? Can you compare it? Are you on the same level, or what is it like?
I think these are two countries where at one point or another there's always an issue of trying to play catch up in one way or another. Like South Africa said, they had their data protection regulation. It was available. It was passed, I think, in 2013, and it was inactive. So, with international pressures, we see African countries struggling to become compliant in one way or another. Of course, because of the size of the economy and the level of international investment in South Africa, there's a much faster advancement in most times. But in terms of we see issues like data localization, requirements for storing of data locally. Those sort of like mirror each other.
Okay.
So yes.
Okay.
Yeah, that's a politically correct answer.
Okay. Yeah, I wonder what you'd have told to Amanda if you're speaking privately. I wonder if that would have been the same answer. But Juliana, when you hear this, how do you compare it for you, and how advanced is it? What does it look like?
Sure, yeah. Well, when talking about internet regulation in Brazil, there are many types of regulation I could mention that somehow relates to the internet, such as telecommunications, infrastructure related. But I decided to focus this conversation on the regulations that relate to content and applications layers of the internet. So I think there are two main legislations that I think are relevant for us to talk about. But before that, I wanted to introduce what we call in Brazil the Brazilian Internet Steering Committee. I don't know if you're probably not familiar with that. It's not very disseminated outside of Brazil, but it's not a regulation, it's a committee. And it exists in Brazil in order to serve as a consultative body for internet regulation and internet development in Brazil. So we have, for example, 4 members of academia, 4 members of civil society, 4 members of the private sector, and 9 members of the government that are part of this body, this committee that is multi-stakeholder, meaning that there are civil society, academia, private sector, and government involved in it. And every time somebody is trying to regulate something in the internet, this body is kind of like invited to give their opinion on it because they have expertise in both in the technical part of the internet and also in the legal. So they kind of like serve as a consultative body for every internet regulation in Brazil. This body is maintained by the domain name system in Brazil. So every time you register .br in Brazil, the funding goes to this committee. Now, specifically talking about regulation and legislation, we have as the main legislation when it comes to use of the internet in the country something called Marco Civil da Internet, which translates as something like civil rights framework for the internet. And it is a piece of legislation that was approved in 2014, so not that quite long ago. And it exists because when talking about regulating the internet before that, people were always mentioning and proposing things that aim to like criminalize conduct on the internet, treat the internet as a space where criminal law would be acting on the conduct that happens. So, and this was very criticized because, well, how can we criminalize things if we don't have a framework for civil rights first, right? So they decided to do this piece of legislation that is kind of like a civil rights framework for the internet, and it establishes rights and obligations in the online space. There are three main points of concern in this legislation, which is net neutrality, which is basically how internet service providers cannot discriminate packages of information coming from one service in regards to the other. So, for example, meaning that your telecommunications company cannot make Netflix run faster than other applications. So this is one of the points of this regulation. And the second point is privacy, so meaning that the users have the right to online privacy, and data collection can only happen if the companies respect some directives related to the rights of the users. And the third is freedom, and when I say freedom, I mean freedom of expression, of course, but what we call in Portuguese freedom of initiative, which I guess in English would be translated to something like free market. So that the internet is a place in which different commercial activities might happen, and the state, even though it has control over some of them, is not to interfere with the commercial practices that happen within the internet. So this is the most important piece of legislation that we have on the internet in Brazil. It's highly, I can say, it's highly approved by experts because it exists. It only became something because civil society, academia, government, and private sector did a lot of contributions on it. So it's not something that was passed by the government exclusively with no consultation. It was like a very collaborative process. It was very well seen, this legislation in the country in general. And the second piece of legislation I wanted to talk to you about is the General Data Protection Law, which was approved in 2018, so exactly 2 years ago. It is a very interesting piece of law because it was inspired by the GDPR, also following the same pattern that you guys were mentioning about the GDPR. So GDPR was approved, and then we kind of like had a fast track for this piece of regulation as well. Even though there are some differences between GDPR and our General Data Protection Law, it establishes essentially the rules for dealing with personal data in the country, both for governments and the private sector. And well, before the existence of this, we had very sparse provisions on data protection and cybersecurity in other legal documents, but they were not unified, they were not consistent. So with this law, we have something that is consistent and that is used both for the private sector and for the public sector. So, well, even though this is a very important law that we passed recently, it's not yet being applied. It was supposed to become applied in this year in January, but due to coronavirus and a series of other things, it has been postponed to 2021. I don't know exactly personally if that's going to be active in 2021 because it has been postponed so many times already that I don't know if that's going to happen again in 2021. So let's see the next chapters of that. But besides this law predicts the existence of a data protection authority that is supposed to be independent from the government. However, we don't have that authority yet. And it's not independent from the government. Like the idea that they have to create this authority is not something that is independent from the government, which I see as a problem because if you don't have an authority that is independent from the government and they depend, for example, on the funding that comes from the government, this can create like some sort of dependence mechanism in which this authority is not going to investigate very deeply into government aspects of data protection, and that's going to compromise the effectiveness of the law in general. That's pretty much how this scenario is in Brazil right now.
That sounds quite interesting. And how do you compare? It sounds like you have quite extensive or some laws right there, which maybe try to, like to be in line with the international standards. But how do you compare that to the to the global market, to the international market? What's Brazil? Are you like at the basic level, at the advanced level, or on the regulations? Are you matching and competing the world standard?
Well, I guess the objective of that, those two laws I mentioned, was to be to bring like international standards to our domestic kind of like law. But what I think in practice happens is even though we have like very beautiful things written in the text of law, when it comes to practice, we don't have that at all because we have a data protection authority that is dependent from the government, so we know that's not going to investigate everything that happens within the relationship between citizen and the public sector. So even though we have in theory all of that is comparable to the GDPR, looks very beautiful on paper, we know that in practice when that's going to be implemented, it's not going to be exactly like that. So that's what I think is the major problem that we have because our legislation, I don't think there's a problem with it essentially, but its application is completely dependent on authoritarian and government forces in general.
Okay, we can understand that from an African perspective. We can understand that. So, Hakim, if I may ask, from a Nigerian perspective, are there a number of legal tech solutions, or a few, or what does the legal tech space look like in Nigeria? Is it a common thing to have solutions being used for the legal sector?
Hope you can hear me now.
Yes.
All right, thank you. All right, so basically, the Nigerian legal space is governed by two main laws. This text is governed by two main laws: the Cyber Crimes Act. The Cyber Crimes Act, law that regulates and tries to prohibit and prevent commission of cybercrime, and as well as a law known as a regulation known as the Nigerian Data Protection Regulations of 2019. And as we've all mentioned, the Nigerian Data Protection Regulation was sort of stimulated by the EU General Data Protection Regulation. And so when you look at the Nigerian Data Protection Regulation, it sort of mirrors the EU General Data Protection Regulation. And in addition to that, I would say that the tech space in Nigeria is accommodating. It's big room for a lot of players to come in and to participate in the sector and to join in developing the sector. But as it is, just like in other African countries, the Nigerian tech space is still growing. A lot of founders have raised a lot of money. Early this year, one of the startups raised, I think, about $10 million or thereabouts. So it's still a work in progress.
Okay. Akin, thanks for that. Sounds like much similar to maybe South Africa and Kenya. But Rosemary, if I may ask about Kenya, what's especially on the legal tech, use of the legal tech, especially in the Kenyan courts and the Kenyan tribunals, and any laws and regulations that have been developed to help in the legal sector to protect, like client information and that kind of thing. Is it anything that has been considered? Is it different from the data protection laws, or what does it look like if someone were to have a legal tech solution that touched on client information, for instance? I think, Rosemary, you're either on mute or maybe you can't hear me. So, Amanda, let's go with you first then, in that case, on especially the legal use of tech in the legal space. Yeah. So, in the South Africa scenario, is it something especially like digital courts and that kind of thing? And how is the cybersecurity kind of laws working towards that?
Firstly, for some years, the judicial system in South Africa has tried or has tested how the court system could move from the manual paper system, the usual normal traditional course that we had, to filing on the e-space, like in the e-space. It has taken quite a number of years, and they had practiced this with the labor court in South Africa. However, thanks to Corona, we've had to fast track that, and now you're finding that digital courts has become a norm. So I think about 2 or so months back, there was a practice directive issued by the high courts, and now all the high courts in the country, you can have digital courts. They are now migrating all the physical files that you would have gone to court with, all the paperwork. They're now moving it onto a cloud-based system. So is essentially the country is moving towards a lawyer doesn't necessarily have to go to court to be able to file something. You can now file it through the e-system that is provided for by the courts. I remember 2 years ago, you couldn't, it was very difficult to even email service. So you had to physically go to that law firm's physical offices and serve them physically and get them to put a stamp on it. And then emailing was a thing that you would have to agree from lawyer to lawyer. And if you didn't do that, it would definitely have to be physical. But we are moving to a point now, and this is as of this year, where digital court is starting to become a norm, purely because of social distancing rules, and you cannot have too many people coming to court and so on and so forth. So there has become that need for legal tech. So as for the laws haven't necessarily changed, and I don't believe that they do need to necessarily change, purely because attorney-client confidentiality is a requirement regardless. And then you do have the data protection law, which has come into effect this year. So that data protection law will definitely cover the attorney and the client relationship, firstly. And then secondly, I would assume that a law firm is not storing all this private information on their systems. It will possibly be cloud-based, or they'll be using some tech firm or the other to store this information. So they will, in all likelihood, have a contract between themselves and that firm. And the data protection law here, even the GDPR states that when a data controller contracts with a third party to process the personal information, they would need to have a contract that would govern this particular relationship. In that way, the third party will then have to comply with the provisions of the data protection law. So in that sense, personal data is protected. However, from a cybersecurity perspective, South Africa just had a really major data breach yesterday, if I'm not mistaken, the day before. One of the major credit bureaus had a breach, and this breach happened apparently, as they say, because an individual contacted them and they said they were acting on behalf of a client who happens to be a client of this particular company, and it was a fraudulent claim, and they managed to access 24 million contacts or personal information. So this is quite a large data breach, and there has been about 5 since roughly June 2020. One of them was a breach on a major hospital group in the country. So from a cybersecurity perspective, we do have laws that are trying to protect the cyberspace. However, the one law that was geared towards dealing with cyber security. It was a bill. It was the Cybersecurity and Cyber Crimes Bill. They since had to remove the cybersecurity aspect of the bill and only deal with the cyber crimes aspect. And that bill has since been passed and will soon be an act. However, that now begs the question of what then happens to dealing with cybersecurity. And naturally, you would then go back to the Electronic Communications and Transactions Act. And you would also deal with cybersecurity from a data protection perspective, because the Data Protection Act does specify that there are certain things that a data controller, in this instance, the law firm would have to do, or the courts would have to deal with, if they want to protect the security, the confidentiality, the integrity of the client's confidential information. I think the legal space, we still do have a bit of growing to do, but we do definitely have laws that can definitely protect. But also you will find that most of these data protection breaches come from individuals within the companies or the different spaces. So it also comes with the mind shift that we do need to deal with personal data in a confidential manner. So the law firm, starting with the PA at the front desk, or the candidate attorney you have, or the intern you have, would have to learn that we have to deal with this information in this way and in this way. But from a legal perspective, we do have some laws that can definitely protect the legal tech space.
Okay, Amanda, thanks a lot for that. That's quite enlightening. Akin, what's the situation? From what Amanda says, if you could compare that from a Nigerian perspective, looking at the potential for tech in the legal side, cybersecurity, and that kind of thing, what would be your thoughts on that?
All right. So in Nigeria, prior to the COVID-19, it was a moot point as to whether court cases could be held online. Say, for example, in a country like China, uh, they have what we call the virtual courts. But in Nigeria, we do not have that. So when COVID-19 came around and the president issued a directive that had to do with the outbreak of COVID-19, based on that, one of the issues based in the directive was that court cases which are essential or which may seem to be an emergency can still proceed. Based on that, a directive was issued by the Supreme Court of Nigeria that court cases can be held virtually. In the same vein, the Lagos State High Court. So Lagos State is the most popular state in Nigeria and is located in southwestern Nigeria. So the Lagos State High Court issued a directive saying that we can now hold court hearings virtually. All right?
Mm-hmm.
But at some point, some people challenged that and trying to query the constitutionality of it and to say whether a Nigerian court has the jurisdiction to hear cases virtually. Based on that, the National Assembly, so the National Assembly is a lawmaking body in Nigeria. They are trying to amend the Nigerian constitution because one cogent issue under Nigerian law, which is in Section 36 of the Constitution, Section 36 of the Nigerian Constitution has to do with the right to hearing, which we have in all countries around the world. But one of the issues with that section is that that section does not outrightly envisage hearing of court cases online. So that was one of the issues that was raised in challenging the jurisdiction of the court. The case went to the Supreme Court of Nigeria, and the court held that hearing case virtually still qualifies as the party exercising his right to hearing. But at the moment, there's still a bill before National Assembly to amend Section 36 of the Constitution so that it can expressly include virtual hearing court cases. So, for example, the proposed bill mentions specific words. So it says that the bill introduced remote hearing of cases and says remote hearing means proceedings of or hearing of court conduct via Skype, WhatsApp video, or any other social media platform or technological innovation. But as it is, it is still before the National Assembly and we still need to know what will come out of it. But in addition to that, someone mentioned that sending of court processes where you have to add other parties, the council of the other side, whether you can send such court processes. Now, for example, the Supreme Court of Nigeria and I think the Court of Appeal allow parties to send court proceedings via email to each other. So the applicant can send to the respondent via email and all. But at the same time, it does not take away the need for the party to file the court process physically. So sending the court process to the party via email and all was seen as good. So it means we want the party to be aware, but you still need to file it in court. Okay, that's what's happening at the Supreme Court in Court of Appeal. But in Lagos State, Lagos allows for e-filing of court processes. E-filing. So Lagos State allows for that. So also the courts, the Supreme Court, the Court of Appeal, and other courts can extend hearing notice there in the past concerning hearing notice. But one issue which I have identified and I've always raised when it comes to webinar like this has to do with the position of the Nigerian law under the Cyber Crimes Act. So, for example, Section 17, Section 2 of the Cyber Crimes Act 2015, Nigerian law, does not recognize the use of electronic signature for court processes. So, definitely, if you're filing the court process, the council will definitely sign it. So, if you're now signing the court process, you produce an e-signature and then file a court process electronically, it's really an issue when you try to bring in section 17, subsection 2 of the cyber crimes. But at the moment, it's not an issue before the court, but it's not an issue before the court. Everybody trying to play as if it doesn't exist, but that's what it is. So some there's a bill before the National Assembly to amend section 36 of the Nigerian Constitution in order to recognize virtual court sessions. Okay, so that now court hearing via Zoom, Skype, WhatsApp. In fact, that bill expressly mentioned these video conferencing platforms. Okay, and one of the issues that we have raised, or I have raised, and some of my colleagues have raised, is that whether there's a need for that bill to mention those platforms. I mean, because one is that those platforms are not Nigerian entities. Because when it comes to hearing of court cases virtually, it also touches on data collection, and data storing, right? For example, on this webinar, in this section, the data, everything you're saying, like which the data is being stored on the database. All right. So I said that one of the issues has to do with file. So one of the issues I said was that whether it was right for the proposed amendments of the Constitution to have mentioned Zoom, Skype, WhatsApp video when these platforms are not Nigerian entities. Secondly, when these platforms do not have their data center based in Nigeria. So, because, for example, this webinar session, the data transmitting that we're transmitting is being stored somewhere in Microsoft database. So, I mean, why should we now have to introduce these various platforms into our laws? Because when it comes to hearing of cases virtually online, data will be exchanged. So it also raises an issue of where the data will be stored. So I have always been of the view that rather than it's good to use these platforms when the Nigerian courts in anywhere in Africa choose to use to hear cases locally, then we need to sort of develop our own video conferencing platforms that will ensure the data collected remains African content.
Okay. I hear you. I hear what you're saying, and that those are very interesting thoughts that you have, especially on the platforms that are being used to transmit data and use of like Skype and Zoom and such platforms for especially for the legal side. Juliana, what can you relate to any of this? Is this something that's happening in Brazil as well? what does that look like?
Definitely. Yeah, definitely. Well, our courts are electronic at the moment. Nowadays, only very old cases are still done on paperwork, or cases that were filed before 2014. The only thing that you used to do in person before coronavirus, obviously, was like things like hearings and things that you had to go there in the court and do in person. But now with COVID, everything's happening online as well. So we have Brazil is a federation, so we work kind of like in state courts. So every state has its own court. The problem is that even though everything is done electronically, every state have their own cloud service that they are using for the cases and for everything that happens in that environment. And the cloud services are different, so they're not integrated. So for example, if I'm a practitioner in Sao Paulo and I need to do something in the Rio de Janeiro court for some reason that's not gonna work in the same system, I have to change the system because there are different cloud solutions that are used for every state. That's a bit annoying when you work nationally, when you're a law practitioner that work in different kinds of courts in different states, because then you have to have login and password for like 20 different systems because you don't have an integrated sort of system. Law practice in Brazil is highly controlled and regulated by the Bar Association. So there are many restrictions to which kind of businesses can do law practice, who are the qualified professional for this, etc. For example, we have some rules that don't allow foreign firms to have their businesses in Brazil without partnering with local firms. So, and also advertisement is not allowed. So of course, confidentiality is an issue, especially when we're talking about legal texts. When we're talking about emerging businesses such as startups that don't rely on their own infrastructure of storage, for instance, for example, startups that sell their services to law firms and to courts, sometimes they don't have the infrastructure to have their own servers, so they rely on third-party service such as like Amazon or Google cloud services. And then this might become an issue when offering their service to law firms, because then the law firm will not only be sharing personal information of the client with the legal tech, the startup, but also with the cloud services that the legal tech is using, the startup is using. So that's like more people involved in the treatment of this data, not only the law firm. That becomes an issue when we're talking about personal data, and also ethical rules when it comes to law practice in Brazil, which is highly regulated as well. I don't know to which extent this cloud situation stops law firms from making businesses with startups. I don't think this is something that would completely stop them from doing it, but it's definitely a concern, and it's definitely something that would raise confidentiality issues that they would have to deal with, sign agreements, sign terms of confidentiality. It makes their life more difficult, definitely. When it comes to applying technology to courts and the public sector in general, that's even more complicated because in Brazil, the general rule for state activity is that state activity is subject to transparency and accountability, and that is the same for the judiciary as well, not only for the executive. So, of course, not all court cases are public due to personal data. Sometimes there are minors involved, so not all of them are public, but most of them are public. So when you have legal tech doing business with the state, for example, when you have like a company that is selling technology to the state, then we have an issue related to how transparent this service can be. Because if, for example, I do like an information request for the judiciary in the state of Sao Paulo, and they have a partnership with this company that does the technology, how are they going to request this technology company to make something public for me, citizen, that am requiring this kind of information? So, and this is specifically difficult when we're talking about solutions that involve artificial intelligence and algorithms in general. Because how can you explain the decision making that is done by the technology to the general public? How do you make this accountable? Because the state has to be accountable. So how does the technology that is being used by the state can be accountable and something that is transparent for me that I am a citizen and I have the right to know that. So that's one of the concerns that we have when applying this kind of technology to the public sector. We already had discussions recently about algorithms that do the distribution of the cases in the Supreme Court. So there's an algorithm that whenever you file something in the Supreme Court, there are 11 judges, and the algorithm kind of like chooses the one that's going to stay with the report of that case. So there's one person that's going to be responsible for the report, and this algorithm is the one that chooses it. And there was an issue because this algorithm was obviously not transparent, and we didn't know what was the criteria that was being used to distribute those cases to the judges. And that makes a huge difference in the context of Brazil because some judges, they are more favorable to certain agendas, and some are not favorable to other agendas. So if you have a judge that's gonna write a report on something that is relevant for your agenda, you want that judge to get your case, and then we don't know what the algorithm is, so the algorithm might be biased, it might not be completely reliable, and this was a problem that we had because we didn't know how do we know that this algorithm is actually being impartial when distributing the cases to the judges. And then some researchers were looking at it because this was not transparent, so they had to request public sector to give them access to that. And some researchers were looking at this issue specifically. But this is definitely something that we discuss here because how can we apply private technology to something that's supposed to be reliable? How do we know if this company is actually handling this technology in the proper way? And well, this is kind of like the scenario in Brazil right now.
Okay, that's quite interesting. I think there's quite Brazil sounds like you're quite a bit ahead when it comes to how long you've been using technology, especially on the legal side and in the court system, because you've been using it before COVID. Well, in most African countries, it's just right now after the COVID situation, that's when most of the courts are now going to do things electronically. Rosemary, for Kenya, for the situation in Kenya, how would you compare it to Brazil? Is there like some learning things you'd need to do, especially on the court system?
That's a very, very good question because actually, just like in many African countries, before the COVID-19 pandemic, it was like unthinkable for you to imagine in one way or another that the courts could accept e-filing. Fine regulations had been set. Some courts had even started on a trial perspective. On a trial perspective that had already begun. And then with COVID, now there's been a force to do that, and not just in courts in Nairobi, but all over the country. Slowly, we are finding a court shutting down. Maybe one COVID-19 case is found, a few others are found. So we're actually being pushed generically just by virtue of the pandemic. So I think it has been COVID inspired technology changes, but that's a very good thing, I think, locally. Because even now, you find many of my lawyer friends, they get up in the morning, get dressed behind their computers, and actually attend court. But also now, that also brings challenges of access to justice. What happens to those people who don't have access? Access to computers, access to even the basics, power and all that. Does it mean that there's somebody somewhere who won't have their case heard? What does it mean, especially for the provision of access to justice? So that's also something that's coming up, and it's with digital right now being such a key focus delivery area for services, then it means that more funding has to be given, more incentives, more infrastructure has to be done. We're seeing growth in Kenya, especially in fiber, laying of fiber optic, because laying of fiber optics and other ways of ensuring that there's network availability or internet availability in different places. So yes, our courts have a plus, but there's still quite a bit of learnings to be done. Right now, we had an ICT policy that was released in Kenya. It talks about data localization, data sovereignty, and maybe having data that is Kenyan sitting in Kenya. Yet in a country like ours, you find that 90% of civil servants use a Gmail account.
Yeah.
Today, Gmail was down for one reason or another. I'm sure government services were affected in one way or another. So what are the new nuances in terms of technology adoption? What do they mean in terms for citizens? What does it mean even for regular users? and even the policies that are being driven in a country. What do they mean for how do you balance the drive to grow local tech businesses, but at the same time balancing creating a space for foreign direct investment in your tech ecosystem? And I'm happy that this was even mentioned. The same thing is happening in Kenya, that there's a push. If you're regulated by the Communications Authority, there's a push to have at least 20%. Before it was 20% of the shareholding to be locally owned. Right now, there's a push to raise that to 30%. The question comes in: what are the practical implementations for this? What does it mean necessarily? Do these requirements directly benefit the growing the local infrastructure, the local ICT infrastructure, the local investment? So there's a lot that's to be decided, a lot that is still yet to be done. Kenya, like in many other countries, finally passed a data protection law last year. The recruitment for the data commissioner began, and as soon as it began, it was stopped by the courts. We're becoming a very litigious nation. Now the recruitment is back on. So there's always one thing or the other, and our adoption of technology laws and even utilizing them to the maximum really requires a lot of insight, and also just looking internally as a nation and even as technology users, and asking ourselves, the decisions that we make today, are they enabling IT, or are we creating barriers? But as I mentioned, and this is my premise, as African countries, we are being asked to very rapidly adopt technology, adopt different legislations. But I think being reflective of the local situation is very, very important, such that we build structures that are suitable to handle the challenges that we face locally.
Okay, that's very insightful. I mean, that's very insightful, especially when you speak about like access to justice. I wonder how Brazil is able to deal with that. Anyway, Juliana, we'll come back to here, like especially access to justice. Is it that everyone is able, like, for instance, to attend court online, or what has the government done to do that? But I also find it quite fascinating that in Kenya, and as in many African countries, when as we are trying to have more of the digital advancements, the government is still increasing the taxes on the digital and e-commerce side. Like within the last 2 years, Kenya has introduced 3 taxes that are targeting the digital sector. So quite crazy. And I wish there was someone from Uganda here as well, because like Uganda, they're not taxing use of internet. And you can imagine, especially if they are using the same internet for justice, especially in the courts. You tax me, I'm unable to access internet, so I'm not able to get justice at the court. But then the government is happy because they're getting money from it. I think there's it's out of sync, some of the measures that are being taken to advance one area, and quite out of sync. But Amanda, in South Africa, is this something, and this is quite digressing because I found what Rosemary just said very interesting, especially on the access to justice. In South Africa, what's the situation like right now, especially now that there's quite high use of technology in the court system? Is this a concern that not everyone is able to get access to justice because of that?
This is a very good point. It's a very big concern, primarily because this is a country of the have and the have-nots, where you find only a small portion of the country have access to the internet, and you find that the majority of the country does not have access to the internet. What happened during March, during the first 21 days of what was called a national lockdown, was that you had a number of increased gender-based violence cases. So someone in this situation who was not allowed to move around, you could not report this matter, you could not take someone to, let's say, maintenance court or to the police station, because you just could not move around. There were helplines that were being offered, but you found that a lot of people do not have access to data. So because they don't have access to data, they cannot report this incident. And if you can't even report an incident, how can you take this person to court, how can you now attend online court? It becomes very, very difficult. You also had issues around labor laws where individuals were not being paid during the first few months of the national lockdown. And the labor court in South Africa is one court where an individual is able to go file matters for themselves. And this is where you're able to just walk in. But now, because you couldn't simply walk in, you had to do it online, you found that there were a lot of people who couldn't access this service, but they were still not able to claim money from their employers. So that they couldn't take these matters forward. So it is a very great move for us to be able to have to be able to use tech within the legal space. However, there is a great digital divide in the country. And I'm just looking at this from a city perspective. You have very remote areas in the country where uh, basic telecommunication services are very hard to access. So even making a simple telephone call is quite hard. What more trying to access the internet? So I know that most people say we will leapfrog, but I do feel that when it comes to the digital divide, this is something that is very concerning. So a lot of people will not be able to access justice primarily because they don't have access to a cell phone, they don't have access to a computer, they don't have access to data, they essentially don't have access to the internet, so they will not have access to justice if they're not able to go to a physical court.
Yeah, that's quite, I think that's a situation that would reflect in most African countries, if I'm not mistaken. I'm not sure if there's an African country that would be top notch on their technology such that everyone is able to access justice online. But Akin, in the case of Nigeria, do you think technology can be used to facilitate justice, like speed up cases? Because there's been quite a bit of writing that in future that technology could be used to like predict the outcome of cases, technology can be used to sort out, speed up the process. In Nigeria, what is it like? Is it a situation more of like Kenya and South Africa, or yeah, how does the future look like?
So in Nigeria at the moment, it's still similar to the case of South Africa and Kenya, but we all believe that at some point in the future, technology will help to speed up cases and to reduce the backlog of cases in courts. Because when a counsel knows that he will be using his data, he'll be using his data and he doesn't want to waste his data, the council or that council won't be bringing up frivolous applications. I mean, one of the things that is plaguing the Nigerian judicial system, especially litigation, is filing of preliminary objection. Somebody is objecting something is not supposed to object to because you just know that your client does not have a good case. So at the end of the day, a case that should be concluded in 6 months or in a year will drag for another 4 or 5 years. But with the internet, we all know that the court needs to sit and one, the court needs to sit. Two is that we know as we're hearing as the case is going on online, we are all expending our data. So the court won't want anybody to waste its time by filing frivolous applications. So at the end of the day, it will help to ensure that the substantive issue in every case is heard instead of preliminary objections and technicalities. So I believe that in the long run, online court hearing would help to ensure justice is done. But then again, we've all noted here, we agree, especially in Africa, that COVID-19 actually simulated this online court hearing in Africa. In Nigeria, for example, we've been talking about this for I think for 2 or 3 years now, but no one did anything about it. But when COVID-19 came, even the president is holding Federal Executive Council meeting virtually. The National Assembly is meeting virtually. The court is meeting virtually. So everyone saw that, this is possible. But when I'm just hoping that we can sustain this, and we can build on it, and we can upgrade our telecoms infrastructure to ensure that there is no lagging when it comes to internet connection, which was something I experienced today. I mean, as in Nigeria now, you probably need to have at least 2 to 3 or even four internet service providers before you can be able to engage in webinar or to have this sort of online session. So so this goes into the cost. It goes into cost of accessing justice, like what was mentioned earlier. So back to the main issue, I would say that yes, in the long run, online court hearing would help to ensure justice is done. But at the same time, it will also make professional fees to go up, because professional fees will go up, because if you'll be representing your clients in a virtual court, you want to have access to the best internet service providers. So, say for example, in Nigeria now, before you can even have engage in webinar or things like that, you need to have like 3 or 4 internet service providers. So, if I'm representing a client that way, I would also have to factor all this into it.
Okay, that's very interesting what you say, Akin. And again, we had a discussion on taxation of the digital economy, and we had someone from Nigeria who was explaining how Nigeria has also introduced a number of taxes to target use of the internet and data. So quite interesting. It sounds like there's a disconnect in, like, especially these areas, and it's when you speak of like the cost that someone would have to incur to access justice is likely to go up. These are very good thoughts that are being shared here. Let me ask the question that has been to you, Juliana. There's a question that has been asked to you on the chat about what is the experience in Brazil with regards to the impact of using tech in the legal system in terms of reduced delays in case completion and the capacity of the courts in hearing of cases. Also, is blockchain technology used in record management to prevent loss of data and maintaining data integrity?
Thank you very much for the question, Jacob. I would definitely kind of like go back to what Amanda was saying about the digital divide, because that's definitely an issue in Brazil as well. In research that was published last year, I think, or 2 years ago, I don't remember, only 60% of Brazilians have regular access to the internet. And that means not even like cable access, I mean like telephone, mobile internet. And so a lot of things that you might do on the internet are limited by this kind of digital divide. And that limits as well access to justice. So even though we have online systems in which you can file cases, in which you can do most of your judicial activities online, this does not mean that it guarantees access to everybody in the country, because that's not true. So most people in the North region, in remote areas, still don't have a good quality internet so they can use to use the court system and to file cases and all of it. Besides all the costs that involves as well, which I'm not even discussing here. Like, this is another issue, but that doesn't mean that everything is working well just because it's online. We have a lot of issues with digital divide, and that affects access to justice, especially now in COVID, because even though you had to file things online, but you could go to the court in person to go to your hearing. But now you need to have an internet that is able for you to use video applications that usually require a lot more data than just simple applications. And that applies to e-government as well, not just the court system, because we are progressing in Brazil to a phase in which most of the government services are done online through an app. Even if if you have like a labor card, is done online. So most of your services are done through government apps. So if you have a regular internet connection that completely excludes you from accessing all of it. And now in COVID, that's even more serious, because most of the government bodies are not even allowing people on site, and not even receiving people in their departments or whatever. So going to Jacob's question, well, definitely we have a good impact when using technology. There's definitely some gains in terms of efficiency, especially because you don't have to move from one court to the other. If you're doing like criminal law, for example, in Brazil, you go to one place, you're doing civil law, that's another place. So if you're a lawyer, you don't have to be moving around the city, you don't have to take pictures of files because we have a lot of restrictions in Brazil with taking the paperwork home. You cannot take like public documents from the court home without a specific authorization, so that's very bureaucratic. So that definitely facilitates all of that for the lawyers and also for the clients because that ends up reducing costs. But at the same time, I wouldn't say it's completely effective because you kind of ended up excluding a lot of people from this system that don't have a regular internet connection or don't have access to that much data in their mobile connections. Towards blockchain, it's great that you asked that. Well, right now, what we have regarding blockchain in Brazil is a lot of speculation and some trials. Nothing really concrete that is happening in the public. Of course, in the private sphere, there's a lot of projects related to blockchain. We're talking about the public sector. There's nothing really concrete being kind of like implemented. We have a lot of things being tried. So we have, for example, for land registry, that's the main use that people are trying to put in Brazil. It's like using blockchain for land registry, for notarial activities in general. That's kind of very in the initial stage. Not at all like other countries such as Estonia or even the UK. I know the UK is implementing blockchain in their archival systems, and that's pretty interesting as well. We're not in that level yet. What we're doing is kind of like experimental and trial phases, but we are looking at it in a certain way. There are many people enthusiastic about this topic and trying to create projects that might be used in the public sector, not only for the financial sector and the private sphere that's already broadly disseminated in a certain way. But that's a great question. I don't know if I answered that completely, but yeah.
Okay. Thanks, Jacob. You could come back if to clarify anything back. But I think at this point, if anyone, I mean, amongst yourselves, like if Amanda, there's anything you'd like clarified from Brazil or from Nigeria or from Kenya, you could ask Amanda if there's anything. If not, we go to Rosemary, then to Akin, then to Juliana, just in case there's anything you'd like to hear a bit more from any of the countries.
Thank you. I have a lot of questions to ask.
Okay.
Primarily because now I have people to ask. But Juliana, I would like to know, are there any ways that in Brazil you have tried to deal with the digital divide? I know in South Africa during this corona pandemic, there has this move to try zero rate certain websites. So by so doing, you would be able to grant access to maybe justice, access to education. So are there any moves that have been done in Brazil to try deal with the digital divide?
Yeah, that's a great question. Well, we have a lot of initiatives, such as community networks. We had the National Broadband Plan, which aimed to reduce taxes for local service providers so that they would penetrate areas that are usually not served by the major telecom companies. So that's one of the initiatives. When it comes to zero rating, I would say that in Brazil, this is more disseminated within the private sector. And not really, the government doesn't have, of course, there are some isolated initiatives, but I'm saying it's not a broad policy from the national government to implement applications that are offered in a zero rating agreement with the ISPs in general. I think that's a great idea. I think that should be more implemented, especially now in the case of COVID. but there's no specific policy on it. What exists, of course, is pressure from civil society. People are aware of the solution, and this is something that is broadly discussed. But the initiatives that we have are usually isolated and not something that is a policy in national sphere, for sure.
Okay, Amanda, hold back on any questions. Rosemary, do you have any question to any of the other panelists? Anything that you'd like maybe to hear more on?
Yeah, maybe a question. What are the key learnings that maybe you'd like to share based out of, like as I mentioned, a number of the Kenyan laws are fairly new and they've not been tested. What are some of the learnings that you've had, especially in terms of implementation? What can you like sort of like give us Kenyan players a cheat sheet of sorts into what we should look out for on a very high level? Of course, not delving into particular sections of law, but what do you think?
Rosemary, and that question you're directing it to Amanda Akin or Juliana or all of them?
Any of them can chime in. It's a very open question.
Okay.
I would have to say we still have quite a lot to learn. A lot of the regulations that we have passed haven't truly been challenged in court. One of the ones that definitely has been challenged has been the surveillance law that we have. The application of it has been violating quite a few human rights. So that challenge is currently in court. Apart from that, a lot of the laws haven't truly been challenged. And our data protection law, although it's a 2013 law, only came into effect on the 1st of July 2020, and there's a 12-month compliance grace period. So maybe in 2021 I can discuss that. But I would also like to know the answer to this question from other jurisdictions.
Akin, do you have any thoughts on that?
So I would say that in Nigeria, the Cyber Crimes Act, which I mentioned earlier, as some provisions of the law have been tested or are still being tested. Most of the time, the guys who are trying to test these laws are the politicians that are trying to protect, their own personal or selfish interests. So, for example, there's a provision in the Cyber Crimes Act that prohibits cyber stalking. Somebody used that provision to say, that a particular social media user, I won't mention the name, is stalking the current president, and based on that, he was arrested, and the rest is history. There's another provision that talks about uploading of offensive content on the internet. So these are so, for example, if you upload a meme about the president or things like that, before you know it, somebody is knocking on your door. SSS, we call them the SSS, the state secret service or something like that. They will come, they knock on your door, and even if you go online to say, there's going to be a revolution, the next thing is, you're making an hate speech, which is prohibited by the Cyber Crimes Act. So the enforcement of the Cyber Crimes Act, to a large extent, is being used by the government to sort of try to curtail people's rights to freedom of expression and speech, right? So, in addition to that, we also have the law being applied as it relates to cyber crime, so cyber fraud. We have instances of that being applied in India, but to a large extent, various sections or provisions of that law is yet to be tested. Is yet to be tested, especially that which has to do with the protection of the data of a user. So, the law, the Cyber Crime Act, for example, mandates the bank to always ensure that the data of their customers are protected. But there are instances where even the banks and some affiliates of the bank are sending you some spam messages, and there's nobody to sort of take that off. So So I would say to a large extent, the law has not yet been tested. And I also want to add that just yesterday, we have a new bill known as the Data Protection Bill 2020. Earlier I mentioned we have the Nigerian Data Protection Regulations 2019. Now we have a new bill known as the Data Protection Bill 2020 was introduced yesterday. So, looking at that bill, it's just like a repetition of what we have in the NDPR and what's the GDPR. So, at some point there might be, if and they've invited myself and some of my colleagues who are in this space to comment and send their thoughts to the National Assembly. But when you look at it at some point, it becomes one provision, contradicting or contravening another position of the law. So, like it was mentioned earlier, in Africa, here we're trying to. I think we should grow at our own pace. So if the way a developed economy would regulate their markets would be different from the way an underdeveloped or a developing economy will regulate. So we can't do things the way it's being done in the US or in the UK. Yeah, there should be standard, but we can't just go out like that because they have the infrastructure and they have the structure for it. Now we shouldn't be just copying, like I mentioned, the NDPR, just copying and then you are pasting, because in a market that is still trying to grow, the lesser the regulations, the bigger it would grow. But when you put in too many regulations, it sort of stifles expansion and the enlargement of the market.
Hakeem, that's very helpful. And I was aiming for us to end like now, within like after 1 hour, 30 minutes. I think we haven't covered some of the things that we had meant to cover. And Juliana, I'll come to you for you to ask if you have any question to any of the other panelists. I would suggest, for myself, I've thoroughly enjoyed this conversation. My goodness, I could go on and on and just listen and learn. But I would suggest to like invite you guys back, maybe some of the areas that we haven't covered, or some of the things that there could be a bit more discussion on, and also definitely put all of you in touch so that for any helpful discussions that you could have among yourselves on this. As we wind up, Juliana, is there anything clarification thought or anything that you'd like to ask from any of the panelists or to them in general?
Yeah, I'd like to ask if there's any regional initiatives in Africa to kind of like promote the use of technology for the legal system in general.
Rosemary?
Sorry, can she repeat that question again? Just sorry.
Sure, yeah. I'd like to know if there's any regional initiative in Africa formed by all the countries, or at least some of the countries, to promote the use of technology in the legal system.
We have the Africa Free Trade Agreement going on. I hope that there'll be issues discussed regarding data transfer, data localization, and even the integration of technology. I think those are levels that should be happening at African. Those discussions should be happening at African Union levels. Yeah, so it is hopeful that we'll have such discussions moving forward. Because the saddest thing about Africa is that very little intra-Africa trade happens, and there's a huge possibility for great benefits to Africans. And you see, right now, the biggest trade that's happening is based on technology and the internet and all that. So yeah, hopefully that we'll start thinking aligned very soon. I don't know if other panelists have an answer to this.
In addition to the AFTA, so the African Free Trade Agreements, there's a need for African countries for all to place the infrastructure that will promote technology in Africa. So it's not enough to just copy the GDPR or trying to domesticate it, right? We need to put in place the infrastructure. Sometimes for example, in Nigeria, I read some provisions of an enactment, and I realize that particular provision does not apply to us, because we do not have the infrastructure in place. So I'm of the opinion that in addition to the African Free Trade Agreement, African countries also need to put in place the infrastructure. There need to be a conscious effort on the part of our government, so the different African governments, to invest in technology and in ICT. So we shouldn't be waiting for Facebook or for Google, to lead the way. Our government make a lot of money from this sector. For example, in Nigeria, the ICT sector, I think, contributed about 3% of the revenue generated. So the biggest revenue sector in Nigeria, as we all know, is the oil sector. But for the ICT sector to have contributed that, it says a lot. And right now, the government is turning to that sector, trying to milk everybody dry, because they know we all can't do without the internet, but I feel that in order to promote ICT, to promote technology, African leaders and governments need to invest in infrastructure.
Okay. There's this, I think, last question that I will ask, that Jacob has asked, which is, what is your views regarding data protection in the wake of the increase of browsing history under the disguise of improving user experience? Because there's a strong argument brought forward by tech giants that they need such data to improve user experience, since machine learning requires more data to be more efficient. So would anyone like to give any quick response to Jacob on that?
As long as we start also learning to use our data. And I think maybe that's where some of these requirements for having a certain percentage in local ownership. But hopefully this actually translates to transfer of skills. Because you realize data sets as they're being used, say, in America, would be very different in African application, that we can tinker with our own data to get solutions for our problems as Africans.
Amanda?
Yeah, I definitely agree. I have also been of the view that we definitely need to have trust designed in the tech that we are using. I honestly believe that a lot of us do like using these services. I like using Google Maps because I like to know traffic on my way to work. I want to know that. So I do want to give them data, but I also want to know that Google will use my data in the right way. So I believe we need to push to ensure that at the development stage of the tech, they take into account how to make sure that they are accountable. Firstly, they're transparent with how they process this information. They make sure that the information